Thank you, Mr. Chairman. I want to, before I get into some other questions, I want to express my concerns over the Antitrust Division's proposed recommendations regarding consent decrees on performing rights organizations, specifically ASCAP BMI. Rather than meaningfully discussing and reviewing the consent decrees, the Antitrust Division appears to have committed instead to reinterpreting existing agreements in a way that fundamentally changes the way license rights are jointly owned music is performed. You've heard this already. The concern can be broken down in a couple of ways. Number one, this goes completely as contradictory to the U.S. Register of Copyrights, completely contradictory to the information that has been given from there. And the Antitrust Division's proposal to reinterpret the existing consent decrees to govern the PROs recommends a shift to 100% licensing and away from the current form of fractional licensing. The Reviewer of Copyrights has previously said it violates basically the principles of copyright law and interferes with creative collaborations among songwriters, negates private contracts, and impermissibly expands the reach of consent decrees. The way I see it, American songwriters are grasping for air, and the Antitrust Division just took them off life support. And there's issues here because in this instance, the acting head of the division of the Department of Justice is making a decision that flies in the face not only of another agency, but also and putting an industry at risk. There is at least the appearance of conflict of interest among this head with the person making the decision at DOJ based on our previous experience. Now, listening to you all day, I'm not expecting a direct answer, unfortunately. But and your answer earlier doesn't ring true. You've answered several times that they're continuing to look at this and be a part. Well, let me just add, I've had conversations with parties that have been a part of this, and they have been specifically told that the division has concluded that it would not be in the public interest to modify these decrees into fractional license. That sounds like it's already been made up. So we're going ahead and just preempting the time, and I would just ask, would you be willing to look at this, considering the concerns here, and do an internal independent review of this antitrust decision's recommendations?
Well, thank you, Congressman. Again, as I've said before, my understanding, as has been briefed to me, is that the Antitrust Division's review and recommendations, the review is not complete and the recommendations have not been made. That while they are consulting with various stakeholders, and I do not know if those are some of the individuals with whom you've spoken, those discussions, I should say, are still ongoing, that it will be still a few more months until
I appreciate that. I'm going to reclaim my time here because this is an issue that I know may not be on your radar at this point. I'm wanting to put it square front and center on your radar because this is a decision that affects a great deal.